SJC-13584, Commonwealth versus Isaiah Fraticelli. SJC-13585, Commonwealth versus Keith Cotto. And SJC-13583, Commonwealth versus Louis Cotto.
Okay, so we'll start with Attorney Curran.
Good morning. May it please the court, Dana Curhan for Isaiah Fraticelli. This court will hear variations of the same argument from all three of us. The argument is that there were 3 guns in the car and there were 4 people in the car. And how do we know that each of us was not the one who wasn't doing the shooting?
Can we make a reasonable inference that the driver wasn't a shooter?
I don't think you can draw that inference.
So you agree that there are 3 guns, there's a 9mm and a 40, right?
Right.
And 4 people in a car.
So
or 3 passengers and a driver.
Right. Here's my contention. My client was one of 2 people who were grabbed running away from the scene. He didn't have a gun on his person. There was a gun found in the front seat of the car, front passenger seat where he had been sitting. That's got Victor Espinosa's DNA on it. There was a gun found in the woods, and that short distance from the scene, that has Keith Cotto's DNA on it. He's the driver. There was a 3rd gun that they never recovered. That's a 40mm. But there was a 40mm shell casing found in the back seat. Our contention is that that was a backseat gun. May have gone out the window. It may have left with one of the people running off. But the point is, there's no evidence that Mr. Fraticelli, who was sitting in the front passenger seat, had a gun. It may very well be that the driver is driving with one hand and shooting with the other. Or it may be that somebody handed...
But why would that... I mean, there's no direct evidence, but that doesn't mean there's no evidence. There's circumstantial evidence that the car remained under control during the shooting, which would tend to undercut the notion that the driver was both driving and shooting simultaneously. So that adds something to the calculus.
I don't think it adds very much. I think
it adds something, and it adds something against the idea that the driver was one of the 3 people with a gun during the shooting, or one of the, using one of the guns during the shooting.
Don't we have one other fact too, which is the car is pulled up so that the passenger side is facing the victim's car, right? So
Yes.
The driver would have to, and there's somebody in the front passenger seat. So the driver, if he's shooting, would have to be shooting basically through his passengers.
Well,
that makes it a little harder for that driver, doesn't it?
I'm not sure. I don't think you have to shoot sort of through him. I think you can reach past him.
That's pretty hard to do without swerving the car, right?
I mean, I don't think the car was under that great a control. I mean, he pulled up past the car, past the truck, and then backed off. And I think you can drive and shoot at the same time.
And roll down the window?
Well, I assume that it was not, it was electric.
I don't think this is necessarily your strongest argument.
No, but I have to make it.
I understand that.
I have made it, but I think there's something to it. I think.
But if you say you think there's something to it, that's if we were to take it in the light most favorable to you, and that's not what we're doing.
Well, I understand that, but we also have 278-33E.
Sure.
So there is some evidence that my client was not one of the ones who had a gun, at least initially, and there's no evidence that he had a gun, or there's limited at best evidence that he had a gun after that. So, because the gun that was recovered with the driver's DNA did not have my client's DNA. And so that is a factor to consider. Mm-hmm. Now, I think I'd like to turn to extreme atrocity and cruelty.
Can I ask you for a
Yes, of
foundational
course.
question on that? I take your arguments that are very well made on the Castillo standard, at least as I think the third factor in Castillo would be the only one at play. But do we reach this where there's a conviction for premeditation and a conviction for atrocity or cruelty?
I think we do, and here's why it's actually important. My client was resentenced under Mattis.
Oh, I get it.
Because of the extreme atrocity conviction, he's not parole eligible for 30 years. If it was just deliberate premeditation, it could be 25 or perhaps 20 years. So that's why I'm asking the court to consider that.
Fair enough. Yep.
And not just as extreme atrocity, but under 33E. Because I think...
We'll get to 33 in Madison in a second, which is
Sure.
an intriguing question as well. So would you agree with me that the only factor under Castillo is the third factor, that the extraordinary, the means that were unnecessary to cause death?
I mean, that may be accurate, but, you know, here's the conundrum with extreme atrocity.
Yeah, the manner and force by which it was delivered, disproportion between the means needed to cause death and those employed, right?
I mean, I think that may be the case, but the bullets, there were 20 shots fired. Only a few of them went into the car. Most of them were caught in the vehicle. A few that got through lost all their force, and so caused lacerations or caused bruising, but no penetration. There was a fatal headshot, and that was, you know, that's really what happened here.
I think in Castillo itself, if I remember right, we rejected the proposition that a single blow is insufficient for atrocity or cruelty, correct?
That's right. And there have been cases saying a single blow is enough, but what I'm saying is I think extreme atrocity was really intended to get to, you know, to get to the Ted Bundys of this world and things like that. To draw an analogy to popular culture, when Michael shot Sollozzo in the restaurant, there was one shot to the head.
Your shooting is more Sonny Corleone on the Causeway.
I was thinking that, but the problem with that is that they didn't kill Sonny right away, and I think he kind of lingered for 30 seconds for dramatic effect. If that had been real life, he wouldn't have made it out of the car. So, you know, I think that is not extreme atrocity. An example of extreme atrocity would be Luca Brasi when they strangle him with piano wire. You know, that I think is what the legislature was thinking about.
There's a generation of people listening to this who don't understand what we're talking about right now.
They should go back and they should watch it. Take the history of film, history of the motion pictures, and it's.
So can I ask you a question about that?
Of course.
So in reading your brief and considering your argument, and I apologize if I'm oversimplifying this, but it almost seems to say that your client should get the benefit, or the defendant should get a benefit of being bad shots. I mean, it almost sounds like that, because you say some of them went into the car, others were blunted, and there was only one headshot. Well, that's because the shots didn't all find their targets. And if we had 20 shots going into this poor man, would we even be making this argument? Would you even be saying that there's not enough?
It's you know, I think it really is an issue where the Commonwealth is saying these 20 shots were designed to inflict maximum suffering. And I don't think they were. I think they were intended to kill him, obviously. And the jury came back and found deliberate premeditation. But I don't think he knew what hit him. And I think that was really the intent. And I think if the intent was to make him suffer.
Well, okay, so
have it.
I'm going to divide the two verticals. I know the last time I asked you a question, you delved into the 33E. I'm just dealing with your direct appeal right now. So for purposes of the cruelty and atrocity, why should we look at that and say that the jury, in the light most favorable to the Commonwealth, should draw the conclusion that you're just asking us to make, that it wasn't to inflict maximum damage or to really let this guy have it by shooting 20 times?
I think they were trying to kill him, obviously. I don't think they were trying to make him suffer.
What's the evidence of that? I mean, how can we know? It could just be as Justice, it could just be that they were bad shots.
I mean, I think they were bad shots, but I also think that, I draw the distinction between a shooting and some other type of killing that was intended to cause somebody to suffer as opposed to cause somebody to die.
The intent to suffer is more encapsulated in the first Castillo factor, right?
I think so.
Right. So and I think you're right on number one and number two. But number three is where the rubber meets the road in this case, that deals with the number of blows and the disproportion between the means needed to cause death and those employed. That's what we're really talking about with the 20 gunshot wounds. So would you agree with me that there was a disproportion between the means needed to cause death and the number of blows, that is the 20 shots?
I think if they fired 20 shots at somebody standing at the side of the road, that might be a valid argument. I think where you're shooting into a car and you have to presume that not everything is going to hit or meet its mark, I think that's where we are. So they're shooting into a vehicle, and I think I don't think the intention was that he's going to get hit 20 times. I think the intention was, even in the light most favorable to the Commonwealth, maybe something will get through, and something did. But it was one fatal shot.
And the car is moving too, so he's going to get shot. He's the driver. It's going to crash. Don't we add that into the equation too? And he does crash, right?
No, he doesn't.
What does he do?
His passenger sat on his lap and drove the car to the next exit and stopped.
I don't know. It seems to add to the problems that he's driving and they're shooting at him.
Well, I mean, it's a problem, and this was not our client's finest hour, certainly. But, the question is, and they've convicted all three of deliberate premeditation. The question is, should there also be extreme atrocity?
Can I get you in your remaining time to focus on the 33E and perhaps some uncharted ground on what do we do with your client's age in 33E standards, which we would take into account, but now in the Mattis world, whether that's still something we should take into account, that he's going to have the benefit of the Mattis decision? Well,
I think Mattis obviously helped a little, but because of the extreme atrocity, he's still parole eligible after 30 years, actually, I think 32.
And we haven't written on this issue, right?
I don't think so, no. So, for something to be extreme atrocity and have him serve a higher proportion of his sentence than under potentially deliberate premeditation.
Remind me of the differential again. The number of year differential is what?
I think it's at least 5 years. I think it might be 20 or 25. I know it can be 25, but there's for extreme atrocity, it's 30 years.
But is this about the 33E or about, whether he should get extreme atrocity or cruelty?
Both.
Okay, so where's the 33E fit in?
Well, 33E fits in because, number one, the court could say, as to Fraticelli, maybe we should drop the extreme atrocity and only convict him of deliberate premeditation. Or maybe you drop it down to second degree.
Why?
Yeah.
Why?
He's 18 years old. He was 18 years old at the time. There's, again, the evidence that he was an actual shooter is very thin because there's nothing tying him to any of the 3 guns in the car. And in fact, the guns probably were not his. So, you know, even if he grabbed the driver's gun and started shooting and didn't leave DNA, you know, this is not something that he planned in advance. I think given the difficulty of his childhood, you know, that's a factor to consider. And, you know, at age 18, obviously the brain is not fully developed, and, you know, we know the science, but should he be parole eligible, for example, after 25 years or 20 years? And that is our contention, you know, in the present circumstances.
I don't think we've ever had to, as Justice Gaziano alluded to, I don't think we've had a chance to really discuss this, but I'm looking for more as to why it would be appropriate to exercise that kind of relief, seemingly just because. A little while ago, you said that Mattis helped a little. It helped a lot, because your client otherwise would die in jail. And whether it's 25 or 30, he's going to have some mechanism by which he could be eligible for parole. So Mattis helped a lot. So you've got to give us something. I'd like to hear something more in the context of the extraordinarily high in constitutional relief he has now that he didn't have before, to say why this makes a difference here under 33E.
I think it makes a difference in that my contention in argument section 2 is that extreme atrocity is, the evidence of that is not compelling. This was not a strangulation case. This was not a case where they tortured him. It was a case where, you know, they did something incredibly stupid and reprehensible and killed somebody, but they killed him instantly, or almost instantly. I know he didn't die right away, but that was, he lost consciousness immediately. And, you know, given that, given his age, given the difficult childhood he had, he was shot, I believe, at the age of 15 and suffered some traumatic effects. He had food insecurity during his childhood. There were all kinds of things going on there.
But the age issue, the age benefit comes from Mattis. Are you saying that he should also get some sort of consideration under 33E for that same, for the age issue?
I think insofar as it applies to extreme atrocity, yes. So that he's parole eligible when he's, you know, 48 instead of 53.
So can you,
No, he's parole eligible at 48, right? He was 18, right? So he's parole eligible at 48, right?
At 48, I think he's got a couple of years on and after for the gun charge.
Okay.
So about 50. And I'd like to see it sooner.
Wouldn't we be undermining the legislature's differential between extreme atrocity and cruelty and premeditation? Wouldn't we be undermining that statute if we do what you're proposing?
I don't think so, in view of the fact that I think this court has struggled with, you know, what constitutes extreme atrocity and cruelty. And, you know, I don't think I've done a lot of murder cases, and I don't think it's necessarily been applied consistently. The factors, things that might be extreme atrocity are, you know, just deliberate premeditation, and something like this that I think is deliberate premeditation but not necessarily extreme atrocity is treated as such, which seriously affects his parole eligibility. So that's really my contention.
so I want to just make sure I understand. If we were to find that the evidence was sufficient with respect to extreme atrocity or cruelty, how would the Section 33E analysis work in your view?
The analysis works because I think in view of the circumstances where it is unclear that my client had a gun, and was one of the shooters. Extreme atrocity may not, and there's no evidence of joint venture, extreme atrocity simply may not apply to him.
I thought your 33E argument on that score was if you fail to convince us on the sufficiency of evidence on atrocity or cruelty, then we should consider it in light of our 33E review, given the benefit of it there.
I think that's right, yeah. I apologize if I haven't been clear. Unless there are any further questions, I'll leave the remaining points of the briefs.
Thank you.
Thank you.
Hey, Attorney Renaud.
Good morning, Your Honors. Suzanne Renaud for Keith Cotto. Keith Cotto is the driver. Just to start off, I want to focus, if I may, on the jury instruction issues. And for that purpose, this issue about whether he was a shooter or just a joint venture, I think becomes a little bit less important on the sufficiency issue. The Commonwealth tried him as a joint venturer. That appears to be how the jury considered him. So when you're looking at prejudice, looking at him as a joint venturer.
Did trial counsel lead the judge down the primrose path of error?
That is a good question, Your Honor. And I think there is...
I've read the inquiry in volume 11 where he says, I want you to throw in the term knowingly participate wherever you can, essentially.
Yes. And he made a mistake.
And he did.
And he did. And this is all...
Hence no objection.
And hence no objection. And so this is all really driven by trial counsel and where trial counsel made a mistake. I'd say this is not a unique situation. A lot of the times when we end up having jury instruction errors, they're given by the judge. They're always not objected to by trial counsel. Sometimes they are at the suggestion of trial counsel. I apologize to the court. There was one case that I read, and it might be cited in the defense brief, where it was a similar fact pattern. But ultimately, whether or not it was trial counsel's fault, it is the judge's job to instruct correctly. So even if trial counsel is saying something that's wrong, that is an incorrect statement of law, it is the judge's job ultimately to make sure that the jury gets the law and the correct statement of the law. And that is not what happened in this situation.
I take your argument, and that's well made, on the intent. I think the other two factors, I'm not so convinced, but the intent issue, the lethal intent issue is problematic.
It is.
But under the standard of review of substantial likelihood, he did properly instruct to begin on shared intent, on shared lethal intent, and then in between sandwich and knowingly participate, which has nothing to do with intent, he does say that is, and then he properly instructs. So where does that line up on a substantial likelihood analysis?
So, Your Honor, I would characterize it a little differently. I don't think he ever gave a proper instruction on intent, because the very first time he so in the participation section, he said, I'm going to just hold off explaining what intent is until we get to the crime. And then he instructs on murder. And the very, very first thing he says, the very first clause that he says, it's the intent to kill or knowingly participate in killing.
He starts out in the Zanetti instruction and says, first, the Commonwealth must prove the defendant knowingly participated in the commission of the crime.
Yes.
So far, so good.
Yes.
Second, the Commonwealth must prove that he did so with the intent required to commit the crime. That's proper, correct?
That's proper, but it's not giving any information about what the intent of the crime is, because the only time that comes out is when you start instructing on murder, and when he specifically says with element 2, here is what intent is. Intent is intent to kill or intent to knowingly participate in kill. That is the very first thing that comes out, and he never really gives any clarification.
Well, he says the defendant intend to kill, and then messes up with the knowingly participates, and then says that is the defendant consciously and purposely intended to cause the victim's death.
So here's my response to that. First, in isolation, if you just, and I know we don't look at instructions in isolation, that one sentence is demonstrably wrong because it's lowering the burden of proof, maybe all the way to recklessness. But what I think is really important here is that in other times when there has been corrections, there have been very pointed language that's used somewhere in the jury instructions. And that is not what happened here. And if you'll indulge me for a second, it starts off with the participation instruction, with the Zanetti instruction, for about 2 pages explaining what knowing participation is. So what happens is that term never gets redefined anywhere in the instructions. So when you get to element 1, which is the action, which is probably the only place where it really belongs, it explains to the jury what the action of murder is. It's causing a murder, or it's taking a step in the action that leads to the death. It doesn't actually say pinpoint the killing, but it says one step. But it doesn't redefine knowing participation, right?
Doesn't he do, I mean, I'm just looking at what Justice Gaziano was reading, because it keeps going too, on 12-147.
Yes.
So let me just read it. To the defendant intend to kill or to knowingly participate in killing Gabrielle. That is, the defendant's consciously and purposely intended to cause. This is what Justice Gaziano read.
Yes.
Then we got another one. 3, the defendant committed or knowingly participated in the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. And then we keep going. And the next one, the second element is the defendant intended to kill or to knowingly participate. Again, the error. That is, the defendant consciously and purposely intended to cause Gabrielle's death. And then this third element, he decided to kill after a period of, isn't that enough?
I don't think so. And this is where I'm heading with this, because really it has to do with how confusing is this to the jury? If there's parts that are wrong and parts that are right, and if the parts that are wrong are never clarified, which is this case, then that is where you end up having a problem. And here, as I was saying, on the first element, they don't redefine what knowing participation is because it was previously defined. Here on intent, the second clause defines what intent is. It says consciously and purposefully. It defines what kill is using the word cause as a verb instead of a noun, which I believe is a little confusing given the prior definition, but we'll leave that as it may. But it doesn't redefine what knowing participation to kill is because that's already been defined for the jury. And I point this out, if you go to the second prong of malice, it doesn't redefine intent again. It just explains what grievous injury is because that's the only term that the jury hasn't heard yet. So what's happening here is that edifying language, that second clause, is not explaining or locking it down to only intent to kill. It's giving definition to terms that hadn't previously been defined.
Can I ask you, when we do our substantial likelihood review, should we also take into account whether this was truly a case of lethal intent or not, where the facts here are very damning on lethal intent, given that 20 shots were fired into a vehicle?
So
this isn't a bar fight where someone accidentally...
No, I know.
Right.
And Your Honor, I do want to loop back to the premeditation in a moment, but to answer your question is this. I think that especially when it comes to the driver and a person particularly who is charged as a joint venturer, and that's why it's important to kind of cement him as a joint venturer and not a person who's a principal. There are a lot of facts out there that indicate that he didn't know this was coming and that he wasn't facilitating it once it started. And I'm not saying that that is an absolute...
What are those?
What are those?
Well, I will say...
Because again, we're reading the record in the light most favorable to the Commonwealth, and he's driving, he's setting the car up so that people can shoot at it. His fingerprints are on the gun, one of the 3 guns.
Well, Your Honor, I would first of all say that you're not looking at this in the light most favorable to the Commonwealth when you're looking at prejudice and substantial likelihood.
Okay, the whole record.
So, and I'm going to just rest on my brief in terms of that particular argument. But his fingerprints were, nobody's fingerprints were found on these guns. Guns don't hold fingerprints very well, and they weren't.
His DNA is on the
His
gun.
DNA was found on the gun, and there's lots of reasons. There's DNA shedding that was testified to. Maybe he picked it up when he was leaving the car. You can't, and not contesting.
Even though he left
constructive possession.
He left his wallet and everything else in the car.
You know, but somebody else might have picked it up, and it's his car. It's not surprising, given what we know about DNA, that his DNA would be found on this. And I'm not contesting constructive possession.
On the gun?
On the gun.
Yeah, okay.
On the gun. But when you look at what could have happened, and this is sort of what comes out in the manslaughter argument that I presented here, you know, he could know, just like they did in the Tavares case, that these folks drew out their guns so they wanted to threaten somebody. It's so highly unlikely that somebody's going to shoot on a highway.
Baxter say Tavares, all those cases deal with people who leave a car.
Tavares does not. Well, Tavares, yes, they were not in a car. But the point in Tavares was the defendant knew that his co-defendant took the gun, knew his defendant was angry, knew all of these things, and yet the court said there are inferences here where you could say that he didn't know he was going to use it. He knew he had it. He knew he was going to maybe throw it around and use it as a threatening weapon, but he didn't know he was going to use it. So in this situation, because we have a lot of gaps in the facts in this case, we don't have language about what they're doing or that they know this person. The idea that maybe he just drew the car abreast so that they could see inside and threaten or see if it was the person, try to get them off on the next highway exit, is as plausible as anything else. And then they started to shoot, and he did not stay still.
I think this is a very hard argument in terms of the facts that we've got. We have video evidence showing a course of deliberative driving of the car as soon as they notice these two people, the victim and his companion, parked on the street. They go loop around the block, they come back, they then follow that car. They wait behind that car when it stopped at a stoplight. They then follow that car up on the ramp to the highway. They then zoom up and drive next to that car. I think it's very hard to argue that if you were intending to simply talk to the people in the other car, that you wouldn't have done it at some point before then. So,
Well, Your Honor.
Whatever reasonable inferences can be drawn from that series of videographic evidence, it seems hard to me to argue that the driver does not have an intent in common with his passengers.
What I would say to that, Your Honor, is that that requires some inferences, and there might be logical inferences, obviously, about what their thought process is, but we don't have anything concrete.
Well, we then know that 3 people in a coordinated way, both timing and otherwise coordinated, simultaneously shoot into the car that they've been following at that point for a minute or two.
So, Your Honor, I'm going to, again, push back on this because I would concede that he followed the car and that he drew up next to it. But why he did that is the thing we don't know. But what we do know is this, especially in the light most favorable to the defendant, or perhaps when you're looking at this as a substantial likelihood issue, we do know that not all 3 of the guns started firing simultaneously.
It's within a second.
Well, but this is this situation, though. If one person starts shooting and the other 2 have their guns, they don't need to rack them. These are semi-automatic weapons. There was testimony from the ballistician that people keep a bullet in the chamber. They could have all started shooting. It's not premeditated. It wasn't expected. And he doesn't stay still. He doesn't stay still to make sure that the bullets go into the side of the car. He's driving faster than the other car.
Premeditated when they stalk the victim.
Because it has to be premeditated murder, Your Honor. It's not again, yes, you could say that there's enough here for premeditated for sufficiency purposes,
Right.
but in terms of whether or not there's an alternative scenario based on what I think are, we know the actions, we don't know the mindset. And so based on that.
I take your argument. When we look at substantial likelihood, we look at the totality of the evidence as opposed to in a light most favorable to the Commonwealth for sufficiency purposes, correct?
Correct. And I think that what's going on here is that there is clearly an intention problem in the jury instructions. And again, and I do want to get back to that a little bit. But you also have a similar situation that animated the Tavares decision, which is the manslaughter instruction was not given. And I think that from what the conception of the facts that I think is it's not a stretch, that there is
20 bullets firing into a car, and we're going to there's not a substantial likelihood of death here.
But Your Honor, the point is that if one person starts and the other join in, that doesn't mean that the driver knew that any of that was going to happen. If he stayed still and made sure that the cars stayed next to each other, I think that inference is what I'm proposing would be impossible to make. But he didn't do that. He's speeding up. And that's what we see on the video is he's speeding up. And
What do we do?
I'm sorry. You say that, but we also have, I think, 5 or 6 audio files of how quickly these bullets came out. So the way that you're slowing this down is almost as if the whomever's driving the car, your client's driving the car, and it's parallel to this pickup truck. And because it kind of pulled up a little bit, seems to suggest that maybe he had no idea that whomever was in the car was going to fire these shots. But what you listen to, these things happen in such rapid, you said they're semi-automatics. So this idea that there's this huge time lag to draw the inference from the totality of the circumstances that you're asking us to draw, I just don't see how that's possible.
well, what we do know is from the eyewitness who testified, the trooper, is that it didn't all start with 3 guns out the window. So ShotSpotter said it was 3 seconds on the audio, but 6 seconds. And yeah, it's a small amount of time, but it didn't start all with the same person. It didn't start with all 3 of them at the same time, according to the eyewitness who was there. So while I take your point, I think when you're looking at if there's any concept of this evidence that supports manslaughter or supports an alternative version of events, we have that here because there are enough gaps in what the Commonwealth presented that you can use that. And when you look at the fact that we have a mistake in the main jury instructions, and then we have the absence of a manslaughter instruction, what happened in Tavares is said that's basis for reversal. And I think that would be the same here because the jury wasn't given the opportunity to really assess what the mental state was of Mr. Keith Cotto at the time all of this was happening and to really see this. And this is where I just want to get back, if I may briefly, to the premeditation point. Because again, it's not, there's a case I didn't cite it, Commonwealth versus Reeves, that has a similar fact pattern to this. But in that case, there had been a joint venturer and the judge was very, very clear that the aggravating factor of premeditation had to be also inhabited by the joint venturer. That it wasn't enough that that the principal had premeditation, that the joint venturer also had to have it. That didn't happen here. The judge never told the jury how to consider premeditation, whether it was part of the act of the crime for which he had to knowingly participate, or whether or not it was part of the intent.
He talks about I take your point that's well made on the intent part of it, on the knowingly participate, but I have more of a problem finding more harmful error on the other instruction on the causation, the first and the third elements.
The first element, I don't think there's an error, except for the fact that it's just repeated language over and over again.
Sure. Right, then third, it says the defendant committed or knowingly participated in the killing with deliberate premeditation. That can only mean that the killing has to be premeditated.
So Your Honor, this is where
And that he decided to kill after a period of reflection.
I think there's a problem with this instruction. Number one, like I said, it never made it clear that was part of the intent as opposed to an aggravating action.
Then he goes on. The second element is the defendant intended to kill or knowingly participate in the killing of Mr. Irizarry. That is, the defendant consciously and purposely intended to cause his death.
And then this is the second part of the problem. The problem is that when you start putting in this language that doesn't belong there, knowing, participate, to kill, it grammatically doesn't make any sense. And it's confusing. And the problem with this particular instruction is, again, all of these terms that are new are defined.
Right, my issue is whether or not the instructions as provided relieve the Commonwealth of a burden. And I take your argument on intent. I'm not seeing it on premeditation.
I would just say that I would say that the premeditation instruction doesn't save the intent instruction in this case because they are.
I agree with that.
They're separated. But I would say that in terms of whether or not it was clear that Mr. Keith Cotto needed to have the premeditation to kill, it gave permission, number one, to these jurors to say, if you have premeditation to knowingly participate in killing, i.e. to drive, that's enough, even though, yes, it was defined more. It suggests that if his co-defendants had premeditation to kill, that's enough, which it's not, that shouldn't be the case. And as I mentioned in my brief, this idea of using the word kill could very easily by the jurors be replaced with the word to act, because it just doesn't make sense otherwise. And they could have misread what the judge was saying. And because these instructions were so very confusing, I think that that part of it is also very confusing. And I'm just going to say that there's nothing about that premeditation. I think that should lock this in. What I think the end result of all this is that for Keith Cotto, at least, who really was tried as a joint venturer, it is not clear that the jury understood what his intent needed to be. I think that justifies reversing the verdict against him. There is certainly, this was not an overwhelming case to the Commonwealth. There was no motive, there was no discussion. We only have some of the video of what happened, and there are other facts on the record that suggest that he didn't necessarily know what that they were about to kill and that they planned to kill. And so with that, I would ask that you reverse the verdict against him. If there are no further questions, thank you.
Attorney Keneally.
Morning, Your Honors. May I please the court, Joseph Keneally for Louis Cotto. Your Honors, my prior counsel covered a lot of ground on that was addressed in Mr. Cotto's brief. I won't dwell on some of those issues too much, particularly the instructions. I think Attorney.
Let me ask you a question that may be unique to your client.
Sure.
As well, and also to the other Cotto. Unlike Mr. Curran, who raises an issue of atrocity or cruelty because of the sentencing under Mattis, your client doesn't have that issue and was convicted of deliberate premeditation. Do we have to reach atrocity or cruelty in your case?
Well, it's Mr. Cotto's position that, as he set forth in his brief, that the evidence was insufficient to prove either deliberate premeditation.
What I want to separate out is we can, I assume you would agree, decide this case solely on premeditation, correct, and not have to reach atrocity or cruelty in your client's case.
I do, but I think that, of course, that, one of the issues in terms of analyzing both elements of first-degree murder speaks to the issue of 33E. It's, this court will make a sufficiency determination as to both deliberate premeditation and extreme atrocity and cruelty. And of course, if it finds one, it does not necessarily need to reach the other. There's no one who can deny that. However, when looking at it for purpose of 33E, the standard, of course, is not the same. This court will not look at the evidence in light most favorable to the Commonwealth. Instead, they'll look at the totality and make a determination as to whether or not the conviction, the verdict rendered was consonant with justice, and whether it was proportionate to other similarly situated convictions.
So can you just help me and address that standard and explain why this case on these facts would be entitled to relief under 33E?
Well, I think that both of these issues go back to the evidence of deliberate premeditation and extreme atrocity and cruelty. I believe that if you look at how this court has made an assessment of how it finds deliberate premeditation, particularly in the context of 33E, it does so by not simply blurring the formation of intent with deliberate premeditation. An individual might pick up a gun and fire it, and that would demonstrate intent. And in this case, I don't think that there's any question that the shooters, whoever they were, intended to acted with malice.
Well, I take your argument, but usually in our 33E cases or close cases of premeditation, it's two people in a bar. There's no reason, and once they're yelling at each other, one pulls out a knife and stabs them. I don't think we've ever had a case where we granted 33E, and you'll correct me if I'm wrong, where somebody's fired 20 shots at somebody.
Well, I think that the issue is not necessarily the number of shots, but the possibility that this was a spontaneous eruption of violence that took place as the cars got onto the highway. The two cars drove up. And
It's sort of unilateral. It's not an eruption of violence. There's no evidence that the victim's car or the victims did anything violent. They're just driving.
Oh, no, I'm talking about from the car. It is unilateral. What I'm saying is that there could have been a instantaneous decision to open fire on this car on the part of the three shooters.
How does that help? How does that help anyone who's in the
Well, because I think that represents the evidence that intent was engendered, but it's not necessarily the same thing as deliberate premeditation. This court has always looked for more when it has made an assessment as to what deliberate premeditation meant. It isn't simply that intent was formed; it's the nature in which intent was formed. And there are two
So
ways.
what's the evidence that we would hang our hat on to that? So when you say that, this might have just been this instantaneous, lapse in judgment that these folks had to just start opening fire on I-91 at this truck, what would be the evidence of that, even if we followed your argument, that we would be able to say this is the kind of thing that might warrant 33E relief?
I mean, I guess, Your Honor, you can look at this case in the context of other shooting cases where there's been a determination that the evidence was sufficient to support deliberate premeditation. And all these cases involve situations where there's evidence of prior hostility. There's been cases where an individual takes a gun or encounters of the victim, hostilities arise. The defendant then leaves, retrieves a gun, goes back and fires a gun. Commonwealth versus Gomez from last year. The defendant was arguing with an individual outside of a bar, left, got a gun, came back.
Right.
Argument ensued. He racked the gun during the argument and ended up firing. Right. There are a number of cases, all in the defendant's brief, where indicate this time and time again, where either there's prior hostilities, there's a gang related.
Yeah, but there's evidence. There's evidence. We cited to evidence in the record.
Yes.
I'm saying, so give us the evidence that would support your view.
What I'm saying is that this court has for 40 years been looking at these particular elements to make a determination that this was not just a second-degree murder case, but it was a case that involved deliberate premeditation. This court would not be raising these issues if they did not matter.
What about the stalking conduct in
Right.
this case? And this is, again, in the light most favorable at this point to the Commonwealth.
Well, I mean, if I'm not sure that this was stalking. I mean, if one was to be getting on the highway to go into 91, this would be generally the route that would be taken.
What about the movements before they got onto the highway?
We have a wonderful compilation video that's in the record. One of the defendants filed it. It might have been you. I'm not sure who it was. But we saw the entire half an hour amalgam that was put into evidence.
Well, I understand that, but I mean, what we would be talking about here is just an entirely random decision to kill two people. There is no relationship between the victims and the defendants. They didn't even know each other.
We don't know that. There's not evidence of it, but we don't know either way, right? I mean,
That's what I mean. We have no.
Well, I mean, right. It wasn't established that there was any relationship between them at all, and by all accounts, there was none. That this was.
Wouldn't it be more perverse if we were to reward someone who stalked an innocent couple and decided to pick them off on a highway?
Well, I mean, I think when you look
Without any, did they just pick them out of a hat?
I think when you look at it in the context of the case, where you have a number of young people acting this way, it does speak to some level of spontaneity, and the fact that this was not, there's no evidence that this was a planned sort of thing. The fact that these opened fire, this might represent.
is there any case, I mean, I understand your distinguishing parts, but where we have sort of what can be interpreted to be a coordinated stalking attack with multiple guns. Have we ever said, granted 33, lowering in that context where you can interpret this as almost an assassination?
Well,
People. I mean,
I don't have any cases where
Because
that's been the case.
isn't that a problem?
But usually when this court will make a determination as to where stalking has occurred, it's been different than this.
We got 3 guns firing at the same time, or roughly the same time, after a car sets it up so that they've got good angles to shoot. This doesn't seem like the cases we've got where we have mentally ill or drunken friends, brawling each other and someone ends up dead or something. This seems very different.
And there's one other component to this, is we are looking at the totality of the circumstances when you're talking about the 33E relief. What about the evidence of consciousness of guilt? I mean, to the extent that you're saying that, your guy may not have known, or anybody's guy may not have known what was going to happen. We have the video from the driver's dash cam, who seemingly is, narrating what's going on with the chase and then the crash, and then everybody empties out. I mean, so, those kinds of consciousness of guilt or there might have been really helpful consciousness of innocence evidence that we don't have here, that the person who had no idea this was going to happen doesn't leave the car and says, hey, I had no idea what was going on. So again, I'm trying to help you by having you point us to where, other than speculation and conjecture, we can point to something that helps us say this is different than what it looks.
I would just, Your Honors, go back to the circumstances where when you look at cases of stalking, it's obvious that this is going on in terms of the context of the relationship between the individuals. There's a reason why these people were doing this stalking. It seems to me that when these individuals opened fire, they had formed an intent to kill. Malice was formed. But there has to be something more than that. And if driving around behind someone, they both get on the highway, I don't think that's enough for a jury to infer stalking from that.
What about the circling around the block once they spot them, the tracking the car out?
Well, I don't think that there's any evidence that they spotted them and then circled around based on that.
And tracked the car. That doesn't show premeditation?
It doesn't seem to be, because...
How are you going to distinguish Commonwealth versus Carlton?
What?
How are you going to distinguish Commonwealth versus Carlton?
Excuse me. I understand that it's close to the same case, but it would just seem to me that in these circumstances that the absence of any sort of information that we can glean prior to the shooting would allow us to make some sort of inference of deliberate premeditation. And remember, when we're talking about
that case had no known relationship between the victims and the defendants.
That's correct, Your Honor. But like I said, what I was suggesting is that when we talk about this case in the context of 33, we don't necessarily have to look at it in light most favorable to the defendant. And really, getting back to one of the points that Attorney Kern made that equally applies in this case, there's little indication that Mr. Luis Cotto participated in the shooting at all. There are 3 guns. DNA was on 2.
Where's he seated in the car? I get them confused.
He was seated in the back seat.
So he's the back seat passenger side?
Yes.
Okay. And we know we've got 3 guns firing. And I can't remember, is he the one with one element of the gunshot residue not on his...
Yes, but I mean, yes, Your Honor, he had it on his hand. Okay. However, that I would submit indicates that represents a negative on a test. I mean, first of all, there were guns being fired in the car. There's no question about that. The fact that there was one element of GSR scientifically represents a negative finding. There's a lot of different environmental reasons why that would have happened in those circumstances. So I wouldn't suggest that the GSR implicates him at all. I would, in fact, suggest that it exonerates him.
We do have 3 guns.
We have 3 guns. 2 of them had Espinoza.
We know the guns are firing from the passenger side.
Well, we know that 1 gun emerged from the passenger side, and 1 gun was found on the passenger side front seat of the car where Mr. Fraticelli was sitting. We know that all of the bullets obviously had to emerge from the passenger side to reach the truck. So of course they're being firing out towards that. However, like I said, we have 3 guns. One had Keith Cotto's DNA on it. The other had Espinosa's DNA on it. And the third wasn't recovered. Now, my client was arrested almost immediately after the crash. If he was in possession of that gun, then the police almost undoubtedly would have found it at some point between where he exited the car and left. So it stands to reason that there's significant evidence that that none of these guns were in his possession, which of course leads to the notion of perhaps him being a joint venture in some respect, and that lends itself to the argument where the trial judge's instruction on intent was compromised by the injection of the intent to participate in the killing.
If we, and I think you conceded that there's lots of evidence of lethal intent here, given the number of gunshots, wouldn't that weigh against the substantial likelihood of a miscarriage of justice, the standard we have to use because there's no objection?
I'm sorry.
Sure. There was no objection to the
Yes, right.
to the instruction. So the standard review is substantial likelihood of miscarriage of justice. If we then should look at evidence of intent to see if this was a close case, a hard case, or whatever, and here I would posit that this is a strong case of lethal intent.
Well, it is a strong case of lethal intent. So I guess the question is, did this instruction actually make a difference? And I think we won't know because the jury came back with its verdict that malice was that murder was found. So by virtue of that, malice.
We have to do that in every case. Every case where we look at substantial likelihood, we have to posit how would this have affected the jury.
No, I understand, and I think there's a chance the jury came to the wrong. They were allowed a lesser standard, and if in fact that instruction wasn't given, it may be that they would have still found that. But given the fact that it was repeated over and over again, it was difficult for the. It's difficult to look at this case and see that and come away without thinking that the jury was left with utterly confusing instructions on every element in terms of the mental states for the charges here. So I think given that, it is would still raise a substantial likelihood. The one last thing that I did want to address here, this was discussed earlier, was the issue of the number of shots being relevant to extreme atrocity and cruelty. When you look at the case law on this, when you look at the way this court has interpreted extreme atrocity and cruelty in the context of shooting cases, and when they look at multiple shots fired, it is almost always in the context of a person who's standing in front of the victim, firing away in order to increase the amount of suffering or even to desecrate the individual after they're incapacitated.
But we handle or resolve the cases that are in front of us.
Yes.
So if those were the facts of the cases that were in front of us, it's not that we're making pronouncements that these are the entire sets of circumstances where we can find this in multiple gunshot cases. We're not saying we've never.
No,
said
I understand.
Focus on this one.
And your footnote was very helpful in your
Yes.
your collection of cases. I appreciate that. What would be really helpful is a case where there was insufficient evidence, where there was a volley of shots, which I didn't see.
I understand that, and I know, Your Honor, we have to deal with the case that we have in front of us, and the fact is, this shooting, when you think about extreme atrocity and cruelty and how it's supposed to be limited to only the most heinous kind of murders. This was a shooting. The volley of shots took place in over 3 seconds. Obviously, it wasn't done in a way that there was a high opportunity to exactly hit the target as easily as if it was point blank range. So the number of shots, I would submit, represents more of an attempt to effectuate the killing than to do any of the things that generally qualify as extreme atrocity and cruelty, the things that fall into that category. Remember, when we talk about was this shooting more than what was necessary to effectuate a killing? Well, we know that the passenger in the vehicle was not even harmed. We know that we don't know when this shot hit Mr. Irizarry, and certainly there's no indication that they continued shooting after they thought that he had hit him. Basically, I think it's fair to say that the defendants didn't even probably know that they shot if they shot the individual when they drove away. There's no saying that they drove away and said, "We got him," or anything like that. So it seems odd to lay extreme atrocity and cruelty in a case where the defendant doesn't even know if he injured anybody. I mean, that's this case. And I think that's a distinguishing factor between because remember, these are supposed to be the most heinous of shooting, of murders. And when you have defendants who are not even, who one can say with fair surety that the defendants were not even sure they hit anybody and even injured anybody, then that just isn't extreme atrocity and cruelty. It doesn't meet the standard.
And again, what are you gleaning that from?
All we can do is look at how this court has analyzed extreme atrocity.
No, I'm looking at this case. What you just said, what facts are you relying on to say they may not have even known that they shot anybody?
There's no evidence that when they sped by in the 3 seconds that anybody saw anything. We have the case that we have, and the Commonwealth did not.
So what would you want us to see? Them stop? To see whether or not they actually killed the person in the Ford?
No, but we're talking about extreme atrocity and cruelty here.
I'm asking you, you're asking us to say that there's not enough here for that. I'm asking you to tell me and point to me in the facts in the record, what would we have to support that?
We have a complete absence of any evidence that the defendants knew if they hit anybody when they drove by. There's nothing here to indicate that, and we can't infer that based on anything. If there's nothing else, rest. Thank you.
Thank you. Okay, Attorney Calaflores. 60 minutes.
I did not know the clock went that high.
Maybe the longest argument in history.
Yeah.
We shall see.
Morning, and may it please the court. Special ADA Joseph Calaflores for the Hamden District. With me is Catherine Johnson, the lead trial ADA. On the evening of November 3rd, 2019, Gabriel and Sandra wanted to go to the casino. They were unfortunately unable to enter that casino and return to their Ford F-150 parked on Main Street. So they went home. However, they did not make it home. The defendants followed them onto the highway. Sandra testified that upon getting on the highway, she heard what she thought were pebbles hitting the truck. Gabriel looked over at her, and something struck his head, and his head turned down. Sandra sat on his lap and drove off the highway. Those pebbles were bullets. Those bullets, came from a Honda Accord driven by Keith Cotto with 3 passengers operating 3 firearms, shooting out the window at the truck. Now, when they came up onto the highway...
Can I ask you to focus on the jury instruction, which
Certainly.
I find very problematic, the intent instruction. Would you concede it was erroneous?
I would concede that the language was not very helpful and potentially...
That's not answering my
erroneous, yes.
question.
Yes.
Was it an error?
It did confuse, and I would say, yes, it is an error.
Okay. So,
There was no objection to it.
right, so My issue, my concern is it takes away the Commonwealth's burden of proof because it says the defendant intended to kill, which is proper, but then it inserts or as a disjunctive, another alternative, knowingly participated in killing Gabrielle Irizarry, which has nothing to do with intent. So it gave the jury the ability to find lethal intent or the Commonwealth to satisfy the second element without a finding of lethal intent, correct?
Yes, and when we're looking at the jury instructions as a whole,
How is that not reversible error?
it's not reversible error where the instructions as a whole did not reduce the burden upon the Commonwealth.
And as,
We're looking at
as counsel pointed out, when the judge gave the Zanetti instruction, the judge said, basically, you have to show knowing participation in shared intent of the crime, period. And that would be to follow. So that doesn't help. The Zanetti instruction doesn't help at all. The only thing I think you have in your favor is after the confusion or the wrong instruction, the judge says that is the defendant consciously and purposely intended to cause Gabrielle Irizarry's death. So help me understand how this is not reversible error or substantial likelihood of a miscarriage of justice.
And I think that language right there that you just quoted is kind of the Commonwealth's saving grace as far as the instructions. And when we're looking at the considerations of the instructions and the verdicts that are returned by the jury, Keith Cotto is convicted of premeditation, and the remaining defendants are convicted of both premeditation and extreme atrocity, which shows that despite this potentially erroneous instruction, they are contemplating everything that is given to them and are appropriately considering the various factors and whether or not the intention was there to kill. When we're
how does satisfying premeditation save a faulty intent instruction? They're separate elements.
They are separate elements, Your Honor, and I'm not saying the evidence of intent to premeditate the murder saves the instruction. I'm saying they are contemplating the instructions as a whole to that one line where the judge is instructing them to find it beyond a reasonable doubt, right? So on page, I apologize, I had a sticky note here.
Does it help, though, a little bit on the third element? Because he goes, 3, the defendant committed or knowingly participated in the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. Does that decided to kill help you out at all?
I believe so, and that is the sticky note right here. That's on transcript page, volume 12, page 146 to 147, as quoted in my brief on page 40. And yes, I think that does help this analysis and contemplating whether or not that he.
Is there any cases that help you in this area, or are you citing any cases for this proposition?
I was unable to find anything that's directly on point, except for the standard, and we're to consider the instructions as a whole. And that is the entirety of the Commonwealth's argument.
Are there any cases that make this error too? I mean, the judge is doing sort of improvisation a little bit. Are there cases that, have we ever addressed this error in particular, or is this a first?
In my research, I have not encountered this, Your Honor.
During Ms. Renault's, Attorney Renault's argument, Justice Gaziano asked her to line up the standard with where you think. Can you do the same for us? Because what's difficult in not having cases that have kind of looked at this is, what are we to make of the fact that maybe there's some language in there that might have some safety valve for you, but it's in the context of a first-degree murder case with multiple co-defendants. What I can only imagine is a really, really long set of charges to the jury that we are to look at this standard of review and be like, oh, in this hour of instruction, there's this clause that he said that should make everything else okay. Can you line it up for us how we're supposed to do that?
I'm not sure of the answer that I can give at this moment of, as you mentioned, the lengthy instruction, except to point out to the overall instruction and the clear language of finding items beyond a reasonable doubt. When we looked at the knowingly participating, causing that kind of language, when we're putting that in the context of the remaining instructions, I believe it is clear what the intent of the jury is when they found the defendants guilty. The overall instructions in the Commonwealth's position, it is clear on what the jury's duty was to find and what level of proof that they must find that fact.
You know the record better than I. General jury form? Or special verdict?
Your Honor, I don't know that as I stand here right now.
If it were a general verdict form, would that help or hurt you?
I believe that would help us, Your Honor.
I assume they had to check off the box for premeditation
Right.
Yes.
or the box for atrocity or cruelty, correct?
I believe I might have my record appendix.
Shocked if they didn't.
Sure they did.
I apologize, I do not have the verdict slips in front of me. The jury instructions are potentially erroneous, and when we're looking at them as
Well, potentially.
erroneous, and when we're looking at them, I don't believe when we're analyzing this, and there's no objection to it, and lengthy instructions, that this is going to override and rise to the level of a substantial likelihood of miscarriage of justice. The instructions repeated the burdens of proof of beyond a reasonable doubt. It identified the proper standings of the co-venture nature of this kind of shooting on the highway. And the jury took their time.
Why does reasonable doubt save you when the jury could find the defendant guilty beyond a reasonable doubt by finding that he participated in the killing as opposed to intended the killing?
When we're looking at that particular language and the participating in to kill, there was that language that immediately followed. And the Commonwealth would just rest on that language about intending to kill.
You're relying on the that is clauses and the fact that this is a case of clear lethal intent.
Yes.
I mean, that's basically what you're not going to try. We don't want this instruction to reappear. So
Correct.
So
Yes.
you're basically, that is clarified it, and this is a, you know, there's no doubt these people were firing to kill. So that's your argument, right?
Correct, Your Honor.
So, counsel, could I press you? I agree that this is a really, really difficult case for the defendants on lethal intent, but we have Keith Cotto. And so having to find that he shared that on this record, I understand that there might be stronger sufficiency cases, but what's the relationship between Louis Cotto and Keith Cotto?
They are siblings.
Okay. Is it a stretch here to think that, you know, you're driving the car, your brother might happen to be in the car and start shooting, that you may not know, but you might still be driving that car, such that you didn't share the lethal intent, the really awful lethal intent of the other folks that might have been in that car, when one of the three happens to be your brother?
And one was a cousin.
Even worse.
When we're looking at this kind of fact pattern on the intent of Keith Cotto, the driver, we're looking at the moments of this so-called stalking prior to, right? We're looking at the entirety of this. And not only do we have them following and turning around in the block, following in behind the Ford as it pulls up onto the highway, the moment before it pulls up onto the highway, they're stopped at a light.
Mm-hmm.
And this ties into a later argument, but if this was the moment that they were going to do something else, if they were going to yell at them, this is a prime situation to accomplish that. They could have pulled up, looked inside, they could have yelled at them or what have you. but instead, Keith Cotto drove that Honda Accord up onto the highway. And the trooper testified that it cut over, pulled even and slightly ahead, and then the shooting happened. And in the record appendix, there's a photograph included of the defendant's car with all of the 20 shots being marked by the rods. And it indicates the angles of the shot. There are shots to the front panel, there are shots to the door, there are shots to the windshield and the side window. What I want the record to the record doesn't really make clear, and this is why I emphasize the cars in this situation. You have a Honda Accord sedan pulling up on a Ford F-150 at highway speeds. The Ford F-150 is going to be slightly higher. So when they pull even, and you see these shots on Exhibit 170, they're in that front quarter panel. They're in that door, which is more level with the Honda Accord. They had to have raised their firearm, pointed it at a greater angle than straight out to reach the head of Gabriel in that car. So when we're looking at it, there's not only a number of shots to the car, but he himself received a number of shots, some of which went through the door potentially. On top of that,
How many times was he hit?
2 to the head, 2 to the leg, and I believe 1 to the abdomen. And when we're looking at the totality of this, either 20 shots, potentially a little bit more when you're accounting for the ones that hit him, 20 plus shots to that vehicle at highway speed is an extremely atrocious way to commit a murder. Not only is it the number of shots, but it's the indifference to that, the prolonging of that act of murder.
I don't disagree with you. I'm just focusing on Keith for a moment and saying the evidence upon which you could say he shared the lethal intent of the other folks in the car.
And certainly,
Would that be just based on the movements of the Honda prior to getting onto the I-91 ramp?
I think that's all we have going up into the shooting, yes. In this record, which is highly...
Does the family connection actually cut the other way in your favor, which is he's not driving a bunch of strangers he doesn't know. He's driving family members, you assume he knows them, has a feel for them and what they do, and he knows it's his gun, or his DNA is on the gun, right? So he's not driving around a bunch of people he doesn't know that he met in a bar 20 minutes ago. He's driving along with his family members. So doesn't that help you?
It does, and the evidence laid out at trial indicates that everyone knew each other very well. From earlier in the evening when they're having dinner at Buffalo Wild Wings with Cotto Sr., to the moment that they're at 65 Beverly Lane in another section of Springfield attending a bonfire. Liliana Martinez, a girlfriend of Victor Espinoza, testified that she saw them all together having a conversation before departing for downtown, returning, and then departing again. So it's not that they were completely unknown to each other. Indeed, they knew each other well.
We have case law that says you can factor that into the calculus of whether or not there's a shared lethal intent based on the relationships of the folks that are in the vehicle?
No, Your Honor. I think this would be a factor to take into consideration of what Keith Cotto as the driver knew in the moments leading up. He knew his passengers well, and he also knew that they were pulling up to the truck, right? We'll never know, and we can't force a defendant to tell us what that is. So we're making these reasonable inferences. And the reasonable inferences here...
We also have to sort through the fact that Keith's DNA is on the gun, but it's hard for him to be the shooter. He may be the shooter, but it's more likely that one of the three others are the shooters, but it may explain why he gave his gun to somebody else. I don't know.
We don't know when that DNA got onto the gun. The events leading up to, we don't know how the firearms got to their hands. The events leading out of the shooting, up through the crash, there's a significant gap where the trooper's chasing them. We don't know what happened with the firearms at that moment. when they take that exit ramp and there's a
There's
motor
not a
vehicle
signi-
crash.
There's not a significant gap except for one of them, right?
I'm sorry.
Two of them are apprehended very quickly, right? The third
And that's
just-
that's what I'm getting at. The significant gap is this moment where they take the exit ramp. The trooper goes the wrong way initially, and then he turns and goes and follows the Honda Accord because he sees it's crashed. He testifies that he saw three people running into the woods. And I remind you that one of the firearms is found in a brush pile in that area between the car and the woods. 3 people go in, 2 people come out, and those are the 2 that are arrested on the bridge. What we're not seeing at that specific moment is the departure of Keith Cotto in some direction unknown at that moment, and Mr. Espinoza, who gets onto the island and is observed on the FLIR from the camera and is later picked up by his mother around 5:30 in the morning.
How long is it between when the car crashes and when the police at least are notified, connected to Keith Cotto in the hospital?
That exact duration escapes me at the moment. I want to say it was the next day, but I'm not positive as I stand.
Was there any evidence in the record as to when he arrived at the hospital or how?
There is.
When was that?
He was in the hospital in the next, I want to say it's the next few days, and he's suffering injuries from the accident.
No, I'm wondering, was there any evidence as to how he got to the hospital or when?
How he got to the hospital.
Or when
That night he was at the hospital.
he was? But we don't know how he got there.
Correct. Mr. Cotto testified, Senior, the father of the Cottos, testified to his involvement and finding his son at the hospital. And so I would refer you to that portion of the record. I just don't recall the specific timing of it as I stand here. So the possession of those firearms, returning back to Justice Kafker's questions and the DNA on that firearm, I think it shows that, yes, he may have handled the firearm, that firearm at some point. However, there is a gap where anybody could have been handling the firearms in the moments before and the moments afterwards.
You want to switch to the extreme atrocity and cruelty, address the key element that Justice Gaziano was focused on?
So when we're looking at extreme atrocity and cruelty, I think that both Castillo factors 2 and 3 are present. And I think the second factor of method or means likely to increase or prolong suffering and the third element of excessive and out of proportion are both present through this specific fact pattern. Once again, we have the highway shooting, which is specifically chosen instead of a shooting on Main Street itself. The act of choosing to wait to accomplish this shooting at highway speeds where there is a significant length of travel to get to that next exit. They had just gotten onto that exit.
So that's premeditation. What about atrocity or cruelty?
Well, I think it does going to increasing or prolonging the suffering. If they don't,
That suffering went before the bullets start flying.
but he is suffering the moment it is going. If they don't perfect that murder, and there's evidence that he didn't pass till later, he is getting shot at that.
Explain the second Castillo element for us, please.
Method or means likely to increase or prolong suffering. And so if their implementation of their shooting of that truck starts with 20 rounds to the car, if they're accomplishing that on the highway and it's not an immediate kill shot that completely knocks the light out, that is going to prolong suffering. He's bleeding out, he's driving down the highway, and he's unable. At best, he's going to be able to get off the highway. At worst, he's going to crash, lose control of his car, and the suffering will be greatly compounded by the fact that now he's not just maybe 2 gunshot wounds or however number, but now he's in a major motor vehicle accident in the middle of the night.
Do we have any cases where someone, the gunshot wounds are either 5 or 6, correct? They're either 5 or 6 gunshot wounds, depending on how you.
To Mr. Gabriel's are, yes.
What does our cases say? I know counsel had the footnote about gunshot wound across your cruelty cases, what did you find regarding similar cases with 5 to 6 or so gunshot wounds?
I haven't found anything that's specifically on point as to a highway shooting that would make it completely applicable here. And I
Take the highway out of it. What about the 5 or 6 gunshot wounds?
there are some cases that show, and I agree with the footnote in his brief that they're most commonly with closer in range where it's an excessive amount to accomplish the murder. And I would argue if we took the highway out and it's stationary car on stationary car, I would still say that this is an excessive amount of shots to accomplish that murder.
Which is the third Castillo factor, right?
And it does blend into the third factor, yes. I would definitely say the third factor is a greater argument here for it. I just would argue that both the second and third. The excessive and out of proportion here is not only the 5, but I would argue that it is everything. If there are no further questions, the Commonwealth would rest on its brief.